Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, April 10th, 2026. We are on voting list number 10, or sorry, 26 rather. And we're going to start off with House Bill 601, and that is Josh.
House Bill 601 authorizes for 3 years the use of stop sign monitoring systems on state and local highways located in school zones in the city of Gaithersburg or the city of Rockville to record violations of state law requiring obedience to stop signs. Existing statutory provisions that apply for other systems used in the state would apply to these systems. By December 1st, 2028, the city of Gaithersburg and the city of Rockville must each report to the Governor and General Assembly specified information about their programs.
All right, so motions for a favorable.
Second.
It's been seconded. This is House Bill 601.
Delegation bill.
All right, there you go. House Bill 601 passes unanimously. We're now Jamie. House Bill 557.
House Bill 557 amends Section 1209 of the Criminal Procedure Article to establish a predetermination review process under which an individual can request specified departments of state government to review the individual's criminal history to determine whether the criminal history would disqualify the individual from obtaining the occupational license or certificate being sought. The bill requires the department to use existing resources to conduct a criminal history review, but also authorizes a department to charge a fee of up to $100 per criminal history review. The fee must be waived if the individual's income is at or below 300% of the federal poverty level as determined by the district court. The bill imposes a reporting requirement on affected agencies. It takes effect July 1st, 2026 and terminates on June 30th, 2029. We didn't receive any official amendment request. There was a note in the committee testimony that health occupations boards would like to be exempted from the bill.
Yeah, the House opted to pass on that.
Okay.
So there's been a motion for a favorable. Yeah, second. All right. Motions were favorable and seconded. Is everyone okay being recorded in the affirmative? All right. Senator Fulton's down. This is House Bill 557. All right, we're gonna go with House Bill. Okay. So now we are on House Bill 1341. That's on the last page, 1341.
House Bill 1341 is an emergency bill that requires public school personnel to notify the county superintendent or the county superintendent's designee if the school personnel is notified of immigration enforcement in a sensitive location that includes the school. The bill prohibits public school personnel from being used at a public school for purposes of or otherwise engaging in immigration enforcement or producing or sharing information or a document pertaining to student educational records or employee personnel records or any other information about or from a student, a school employee, or a student or school employee's family or household for purposes of immigration enforcement. This is the cross-file to Senate Bill 810, which has already crossed over to the House. It's primarily assigned to EEE. So as EEE passed it, it was identical to the Senate bill that passed the Senate. However, since EEE has passed it, the House has passed Senate Bill 810 with a minor non-substantive amendment. That amendment changes a defined term so that the bill as it is before you, and there's a reprint in your voting packet of the amendment that EEE adopted. The bill uses the term judicial officer. So since EEE has sent it over here, the House has amended Senate Bill 810 to instead use the term covered officer. The actual definition of the term remains the same between both bills.
Yeah, I mean, just procedurally, if it's procedurally, if it's a non-substantive thing, and adopting our change would gum it up, and that means we have to go back. So if it's non-substantive, I mean, I don't want to slow the bill down, so.
Deal with it in conference if, so we
Send it back.
And then it would be done.
right. Well, when I say send it back, I mean, because EEE is primary, so EEE would also have to, yeah,
I'm saying to the other chamber.
yeah.
Senator James.
I got confused on Senator King's bill. One of the problems I was having was our terms of judicial warrant versus administrative warrant. And my research indicates almost every deportation comes after an administrative warrant, and there were some issues about whether that gets due process, but those warrants aren't issued until after a court proceeding. So I'm not sure what the posture of this bill is. So I have a problem with us not being correct in our terminology, or at least not tracking the way deportations do occur and how they don't occur. But what is the posture of this bill now? And am I on the right bill too? Is this right? Is this a cross-file to the bill that dealt with judicial warrants versus administrative warrants, or is it different than that? Because if it's just school records, then I'm fine with the bill. I'm just not sure.
Right, so the way this bill works, as it was passed by both chambers, in order to override these requirements, you would need a valid judicial warrant. So an administrative warrant would not be sufficient to override the requirements, which are
But as
essentially
it first came in, it was just about school records, right? But now it's been greatly amended. It's because I'm looking at, let's see. I've got so many versions here. Let's see. What number are we on again? It's cool. Yeah, I think my staff threw a bunch of bills in here because I think we're borrowing from different bills. But this, what I just described to you, like, we're using that term judicial warrant in terms of it sort of indicating when a deportation order would be considered acceptable to us, even though almost 99.9% of deportations occur through administrative warrants?
So the bill,
Or what is
the
that?
kinds of court orders and warrants I think the bill is contemplating would be like a subpoena or a warrant for documents, because it's kind of about when school officials can, produce documents.
Oh.
So
So this, okay, this is not about people. This is about school records.
right, it would be about kind of when they're allowed to produce those
Okay, I
records
feel
about
like
students.
Rosanna Dan is saying, I'm sure most of you are too young, but never mind, okay? Okay, do you know what I'm talking about? Never mind, because there's a lot of bills been floating around here. Okay.
There is a reprint of the most current version of House Bill 1341, and the amendment on top of that that the committee would be considering is just anywhere that the reprint uses the term judicial officer, it would be covered officer instead. So, and that isn't changing either way, but the current definition is an officer who may make an arrest with or without a warrant for violations of the United States Code and carry firearms in the performance of the officer's duties. Yes.
So let's move the amendment. All right. Now the bill's before you as amended. And now, is there any other? All right. So now this bill as amended is back in the posture as the Senate bill. So motions for favorable with the amendment. Same vote, yeah, the same vote. Well, we can find out.
Yes, Golden, James, and McKay, Warren, because we're missing a member.
I know.
Golden, James, and McKay. Yes. Aiden, James. Okay, it's 6-4.
All right, 6-4, with the amendment, right?
Yeah.
All right.
Who wants to start? Josh?
All right, we're going to toggle off the list to the concur, not concurs, and just, again, briefly provide the explanation as to why they're not on the list.
We just got them. We just came through.
540.
Like, what we good for.
Senate Bill 540, as passed by the Senate, the bill prohibits a private home detention monitoring agency or its agents or employees from soliciting business on the grounds of a courthouse or correctional facilities. The House amendments make the bill identical to the cross-file House Bill 899, which is already passed out of the Senate by making the prohibition apply only to the agents and employees of the home detention monitoring agencies.
All right, there's a motion to concur. All right, is everyone okay being recorded? Any affirmative concurrence? All right, excellent. Who's next?
I'll do it. 98. Sorry. Senate Bill 298, we have a concur, not concur request. Senate Bill 298 is Department of General Services, Maryland Capitol Police, statewide jurisdiction. The bill alters and expands the jurisdiction of the Department of General Services and the Maryland Capitol Police within DGS. Takes effect July 1st, 2026. There is a House amendment that actually adds conforming language. There was a floor amendment to the House version that provided that before a police officer of Maryland Capitol Police within the Department of General Services exercises the powers granted under this act in Baltimore City, the Maryland Capitol Police must enter a memorandum of understanding with the Baltimore Police Department. The cross-file bill is already passed and enrolled, so this conforms it to the version that's already passed. Concur.
All right, motion to concur. Is everyone okay being recorded in the affirmative for the concurrence? Excellent. Who's next? Yeah, concur. Yeah. $346.
Senate Bill 346, as passed by the Senate, authorizes an aggrieved party or the office of the Attorney General to bring an action against a covered officer who, under color of law, deprives the aggrieved party of a right, a privilege, or an immunity secured under the law. An aggrieved party or, excuse me, or OAG may seek damages and declaratory and injunctive relief in an action brought under the bill, and the court may award reasonable fees and costs, including attorney's fees and expert witness fees, to a prevailing plaintiff. The statute of limitations for a cause of action is 5 years after the cause of action accrues. The bill contains a severability provision. The House made some technical changes to the purpose paragraph and added language that allows an aggrieved party to bring an action against the covered officer that deprives or causes or allows the aggrieved party to be deprived of a right, privilege, or immunity under the law. The Senate has already passed HB 351 with these identical changes. So the motion is to concur.
The House Bill is 351, not 332?
351, yes. Yes, it's the No Kings Act. The HB 351 was not a designated cross-file in the system, but the House amended it to be an almost cross-file.
All right, motions for the concurrence. Is everyone okay? All right.
House Bill 107 requires the establishment of the Intelligent Speed Assistance System Pilot Program, which allows individuals whose license to drive has been suspended for accumulation of points for specified offenses to receive a restricted license requiring the use of the Intelligent Speed Assistance System. So there has been an agreement on this bill, and the two bills are nearly identical. We will, I think, shortly have the Senate bill back for a concur, not concur. There's one small technical fix that is in the Senate bill but not in the House bill. So I think the plan is to not, so they have not concurred on the House bill. We will not recede. It'll go to conference just to fix that one minor issue to make the two bills identical, and that should fix all the issues. Not recede.
What's your pleasure? All right, not recede. Appoint a conference committee.
House Bill 907, this is criminal law, third-degree assault. The committee previously moved to not concur in the House's Senate amendments to, or the House's amendments to Senate Bill 514, which is the cross-file. The committee appointed a conference committee. And this is a recede message from the House. So being consistent with that, you would move to not recede and appoint a conference committee.
Not recede? All right, great.
Second. So House Bill 153 requires a landlord of residential rental units in apartment buildings with 4 or more individual dwelling units to provide air conditioning from June 1st through September 30th each year as specified, unless otherwise exempted under the bill. Landlords are to provide air conditioning in residential rental units beginning June 1st, 2026 for newly constructed units, and 2 beginning October 1st, 2026. For existing units that undergo renovation, that includes the replacement of substantial upgrade of electrical systems or heating systems. The bill applies prospectively only and does not have any effect on or application to any building construction or renovation for which the building permit is issued before the bill's effective date. And so the Senate raised the limit to 10 apartment buildings, and we also had language saying that the bill is intended to preempt and supersede, and the House bill allowed local jurisdictions to make more stringent air conditioning requirements. So if we want to be
We'll just
consistent.
not recede.
Not recede.
Appoint a conference committee. Yeah, you and Jeff.
Senate Bill 747, as passed by the Senate, requires unit owners in residential condominiums, subject to limited exception, to maintain certain insurance coverage that meets specified requirements. The bill also alters the liability of a unit owner when damage to the condominium originates from the owner's unit. Further, the bill requires unit owners to provide proof of the insurance to the Council of Unit Owners annually and upon request. And 2, removes the limitation for the governing body to only annually assess owners responsible for damage. The absence of insurance coverage required under the bill does not limit an owner's responsibility for damage as specified. As amended by the House, the bill now prohibits the bylaws of a condominium from requiring a unit owner to maintain an insurance policy that includes coverage in excess of the minimum requirements under the bill. The House bill cross-file did not receive a vote. So essentially, the question is whether the body wants to concur in the amendment to require or to prohibit individual condominiums from allowing higher premiums or higher insurance coverages. So the motion is to concur.
All right, is everyone okay with that? Yeah. Excellent.
Senate Bill 274, as passed by the Senate, alters the statute related to housing discrimination to prohibit a person from acting in a manner that has a discriminatory effect. As amended by the House, the Senate bill is now identical to the cross-file, except it does not contain the uncodified provision stating the legislative intent is to be consistent with current case law and regulations. So essentially, both bills are the same, except for we added the uncodified provision to the House bill. So the House took out, right now we have the Senate bill without the uncodified. So essentially it's the same as it was originally. We added the uncodified. So the motion is to concur.
Okay. Is everyone okay? Excellent.
I'm not saying anything.
All right, let's do House Bill 336.
Thank you, Mr. Chair. House Bill 336 prohibits a district court commissioner from issuing an arrest warrant based on an application for a statement of charges filed by an individual who is not a police officer or state's attorney, and establishes a new procedure for the issuance of a criminal summons or arrest warrant by a district court under these circumstances. The bill also requires the Maryland judiciary to report specified data to the General Assembly.
Sorry, Council, so my apologies, my apologies. Yeah, blame my last real quick. We do need to get these judge bills done first. I want to make sure we get those two judge bills done first. Who has those? Is that Shamari or is that, hold on.
Yep.
Yeah, it is Shamari. Hey, Shamari, sorry, I just cut them off. We do need to get these two bills done, 493 and 543, on the third page. So let's go House Bill 493.
So House Bill 493 alters the number of resident judges of the circuit court by adding one additional judgeship in St. Mary's County. The bill also creates an additional district court judgeship in District 11 to be appointed from Washington County. And so this was recommitted, and so we need to reconsider the vote. There is an amendment as well in your packet. So the amendment just strikes the language adding the judge in St. Mary's County. So the bill would just add one district court judge.
All right, the motions to adopt the amendment has been adopted. Now the bill's before you as amended. Motions for a favorable with the amendment. Is everyone okay being recorded in the affirmative? Excellent.
We could, but it's up to the committee.
Senate Bill 336 prohibits a district court commissioner from issuing an arrest warrant based on the application for a statement of charges filed by an individual who's not a police officer or state's attorney, and establishes a new procedure for the issuance of a criminal summons or arrest warrant by the district court under these circumstances. It also includes a reporting requirement, and there is an amendment in your voting packet.
So what?
Bill number is, House Bill 336. The amendment is, where are the staples?
Yeah, it's on the wrong side of the paper.
Yeah. Strikes a, well, I'll start with page 3 of the reprint. Would provide in statute that an application for a statement of charges shall be filed under oath subject to the penalty of perjury under 9-101 of the criminal law article. It otherwise retains the language from the House bill, which creates a new section and would provide that on review of an application for a statement of charges submitted by an individual who is not a police officer or a state's attorney, a district court commissioner may issue a summons if the commissioner determines that there's probable cause to believe that the defendant committed the offenses or offenses charged in the charging document, but may not issue an arrest warrant. Further, the commissioner would need to refer an application for the statement of charges for which a summons was issued to the state's attorney's office for review and a prompt determination of whether a request for an arrest warrant shall be made if the district court commissioner finds that there is probable cause to believe that the defendant poses a danger to another person or to the community. On receipt for an application for a statement of charges, the state's attorney shall promptly review the case to determine whether the request that a judge of the district court issue an arrest warrant. This strikes a requirement that came over in the House amendments that the state's attorney would review the case as soon as practicable, but not later than 72 hours after receipt. On a finding of good cause, a judge of the district court or a judge of the circuit court may recall a summons and issue an arrest warrant. The district court judge or the district court shall inform the victim of a crime whether charges have been issued in response to an application for a statement of charges filed by the victim. It retains the reporting requirement and, sorry, it's just a little bit backwards. Sure, the amendment number is HB 336/943-621/1. Finally, there is a provision on page 5 of the reprint that includes 9503 of the criminal law article, which prohibits making or causing to be made a statement or a false statement or report to an official, it increases the penalty for that crime from its current 6 months and instead would make it a 1-year maximum penalty, and also provides in that statute that in addition to any penalty imposed under subsection B of this section, the court shall order a person convicted or found to have committed a violation of this section to pay restitution in accordance with Title 11, Subtitle 6 of the Criminal Procedure. So it's requiring restitution, and then there's clarifying language that it may not be construed to limit the amount of restitution that the court may order. And that's the amendment.
Thank you, Mr. Chair. Jamie, can you walk us through, so in essence, what this is doing is saying that no longer can any individual go to a court commissioner and get an arrest warrant. It is only law enforcement and state's attorneys. Is that right?
The commissioners would not be the ones responsible for issuing those warrants to where the statement of charges is filed by a member of the public or a non-officer or state's attorney.
Or a non-officer?
Can I don't want to use this, I want to just only respond to the questions because if you had something to correct on that or.
No, I was just, that was it, but it could be reviewed now by the state's attorney's office, so it still could be escalated, but it would allow them to issue a summons, a criminal summons, which is still effective of arrest, but everything would be reviewed through the discussion last night by the state's attorney's office that it could be escalated.
Right, but it's not the same as an arrest.
A criminal summons is an arrest.
So they're brought in immediately?
Their attempted service. Mm-hmm. Criminal summons is an arrest.
So what's the difference between a criminal summons and an arrest warrant?
Criminal summons is served on them, and they sign a receipt for their court, or for the charge and for their court date. A warrant, they're actually
Taken in?
taken to the detention center.
Okay, so they're served a criminal summons and then they stay where they are?
Yes, and there's usually conditions, but yes.
Okay, so if somebody goes in and they can't get an arrest warrant, so the person can't be taken. So they stay there. Mm-hmm. And then at some point, promptly, whatever that means, the state's attorneys are going to review the case?
Correct.
Is that right, Jamie? No, it just says promptly.
So promptly, just to clarify the process here. So the district court commissioner would make a probable cause determination on dangerousness. At that point, that would be where they decide whether to forward the state application for a statement of charges to the state's attorney for review. And then the state's attorney applies to the district court for that arrest warrant based on dangerousness. So the district court judge is now responsible for the issuance of the warrant.
Okay, so if I'm understanding this correctly, somebody has come in and said, for example, my partner just beat me up. And the commissioner says, I can't issue an arrest warrant, but we'll get him served with a summons, a criminal summons. So now that partner is still in the home and he's pissed off because he's been served with a criminal summons. And then at some point, the state's attorney is going to review that. Do I have that right?
What you described as far as the order of how that goes is accurate.
Okay.
That's what I'm saying.
Senator.
Yeah, so in that scenario, and obviously we want to protect everyone, so in those type of situations, a domestic type of situation, those victims have up to 48 hours to file a complaint, and law enforcement can take an official action and actually an arrest within 48 hours.
I'm not there yet. That's a different,
Well, actually, it's not. If they call the police, then the police can do the investigation
I
and
understand that,
have
but
the
I'm not
and do an
at
immediate
the,
arrest.
I'm not at the point that they're calling the police. I'm just at the point, we're just focusing on, they don't have the ability to go to the commissioner and get an arrest warrant.
But
That's,
they could still go get a TPO, which would allow them to have them removed from the residence.
I understand that.
Okay.
I
Just-
understand that.
just
That's also a
showing there's-
different process. That's the
Sure.
civil process. That's a different type of relief that somebody could get. Okay.
No.
Okay. So then going back to the perjury statement, so that now only applies to law enforcement or state's attorney, right?
I actually asked the district court about this, and my impression had always been that if you are making a filing with the court, that you are doing so under penalty of perjury. When I asked about the specific procedure in this, for any individual who's not a sworn official, like a law enforcement officer, according to representatives for the district court, if you file an application for a statement of charges, you are placed under oath, and then you would be subject to penalties of perjury already under existing practice. So this more or less just codifies existing practice as far as the requirement that it be under oath and subject to penalties for perjury.
Okay. Okay, so that's for the statement of charges. So what I'm trying to figure out is the entirety of 6, so top of page 3, is that now just for law enforcement and state's attorneys?
Right.
Okay, so then the application for statement of charges shall be filed under oath only applies to law enforcement and state's attorneys now, because they're the only ones that it can apply under this section?
No, I would read that as applying universally. The 2607 is still, as a whole, describing the general rule for filing an application for a statement of charges.
Okay.
Mechanically, how it's working is at line 3 on page 3. It is saying that subject to 2607.1, which is where these new requirements for non-law enforcement officers, non-state's attorneys is coming in. But these are all still the requirements generally for the issuance of a summons or a warrant based on a statement of charges. So yeah, I read that as being universally applicable as far as the under oath and subject to penalties of perjury.
Okay. And so then on page 5 of 5, so criminal law 9-503, what is that?
9503 of the criminal law article prohibits a person from making or causing to be made a statement or report if the person knows it is false in whole or material part to an official or unit of government. And then there's a requirement that there be intent that the official or unit investigate or take some action in response to that false report. So that's generally the statute that look at when it's if you made a false report to a police officer or something like that, that would be, I think, the most likely place where you would find a charge. That's different than the other statute, 9101, which is committing perjury under oath, which is also referenced in the bill.
Okay, so 9503 is not limited to commissioners, so we're pulling in something different from
Right,
commissioners here?
it's universal, sorry, I don't want to say universally applicable, but it's more broadly applicable to making a false report to a unit of government, which I think would cover the situation where you make a false report to a commissioner.
But we already dealt with that.
You're
With the
kind of doing both, yeah.
Okay, I don't recall any testimony about this. Do we know why this section is in here?
Yeah, that was suggested by Delegate Moon in the House. There was proposed language that he had put to the committee. And his amendment did both. It addressed the raise in the penalty for 9503, but also the cross-reference to 9101, which is perjury.
So is this adopted by the House, or is this what we're adopting?
This was just what was proposed.
To this, okay, so Delegate Moon didn't get the amendment on in the House, so he's proposing it to us to adopt.
He's
I'm
not,
just getting procedure.
no, he's not, it was an amendment that he offered, and then I saw it and put that into this amendment.
Okay, okay. So going back to who can go in and ask for an arrest warrant. I understand that a victim of stalking or domestic violence can go to a police officer. They don't always, and they have a lot of reasons why they don't. A lot of police officers don't treat them well, don't believe them, don't listen to them. We had a case in Anne Arundel where a woman, just this week, where a woman had been choked. She called the police. They arrested her and the person who assaulted her. The level of domestic violence in law enforcement families is high. So we may be asking somebody who is the victim of domestic violence by a law enforcement officer to go ask that very agency where their abuser works to arrest them. So we are taking away a really important route for victims. And it's not just victims of intimate partner violence, it's actually also victims of stalking. So as we were talking about this, just yesterday, somebody came to me and described to me an incident on their campus where a young woman had been stalked. She went to the police. They said they couldn't help her. This person had to walk around campus to keep her safe from the stalker. The stalker threatened her. Law enforcement said they could not help her because when he threatened her online, she did not respond by saying stop. So she went to a district court commissioner and got that person arrested. It was the commissioner. And so I'm very, very concerned that if we pass this like this without providing protections for victims of stalking or intimate partner violence, that we are setting these people up for serious harm. And I think there is a way to craft it very narrowly so that we are providing protection and we are addressing the abuses that this bill is designed to address. I think we can do both things.
Thank you, Mr. Chair. I want to make sure I understand the opportunities for arrest warrants that exist under the bill. So under the bill, if a person files the application for statement of charges and the commissioner, similar to the process now, finds that there is a threat to the person or to public safety, they would take that application and they would approve it, but they would send it to the state's attorney's office for review. I want to make sure that in the intervening time, what's not happening is an attempt to serve it as a summons, but it would go to the state's attorney to review it so that the state's attorney makes the determination on it being a warrant, which was appropriate for arrest. Because I think you raised a great question about if they're going to knock on the door to serve it as a summons, is the person now on notice? And if, let's say the two people live together. But is it that it would go for review as an arrest warrant so that the person is then reviewed to be arrested? Is that the mechanics of how it would go from 1, 2, 3?
The summons be approved by the, or issued by the commissioner. And it is not until the state's attorney actually reviews and then makes an application to the district court judge at some later time that an arrest warrant could issue. So as far as just practically, would the person be on notice if a summons was issued and then served? Yeah.
So in the intervening time, it's our understanding that the summons would be issued and they would be attempting to serve the summons while it was still being reviewed for an arrest warrant as well?
Correct.
Okay, so we wouldn't slow down any process in terms of the criminal procedure starting and the person being served. That would still be happening, and then perhaps they would be served and then also picked up on an arrest warrant if it were reviewed by the state's attorney and the judge, and then they found it appropriate for an arrestable offense.
Correct.
Okay, and are we talking about the same commissioner where a person would go for an interim protective order if the commissioner said, hey, I have to refer this to the state's attorney for review? Could that person in the same process at the same place at the same time also ask for the opportunity to fill out an interim protective order to have that person removed from the home if, let's say, they had the same home, or if that person knew where they worked or lived or all those other intimate details, to make sure that they had some immediate protection from that person interfering in their life if it were a threat to their safety, if it were that sort of crime.
So I was actually about to go there. Mechanically, you do still have the protective order available so long as you are a person eligible for relief under the protective order statute. Yeah, my understanding is that it would be available to you to apply to the district court commissioner for that interim protective order until you could get in front of a district court judge for a temporary protective order.
Okay, and those have to be served as well before they have a practical effect as well, correct?
That's correct, yeah.
Could the same officer that's serving the protective order also serve the criminal summons, and in the same act of service, serve a person with both of those things, and then you're now on notice about the criminal case, so all of those things kick in, and then you're served with the interim protective order and removed from the home? Similar as you would be in an arrest, you're not taken into custody, but you are removed from the person's home and you are on notice that you can't contact them or whatever the other elements are of a protective order. Could all of those things happen in the same time frame?
I think logically that follows. As far as the whether that would actually happen and that it would be the same officer who's serving the person with the summons and a interim protective order at the same time. I'm not familiar enough with actual the on the ground execution to really say definitively, but yeah.
Okay. Okay. I appreciate that understanding. Thank you.
I've been going through, it's a very complicated statute, and frankly, it's confusing. However, I think I've traced it through. A member of the public can go to the commissioner and get a warrant so long as the commissioner finds that, thanks to the affidavit, that probable cause show that the person's committed the offense, and the person who's applying is a victim eligible for relief under Section 4-501 of the Family Law Article. I've got that up here. Person eligible for relief includes the current or former spouse, a cohabitant of the respondent, a person related to the respondent, a parent, stepchild, a vulnerable adult, an individual as a child in common, a person has a sexual relationship with the respondent within a year, long list of people who are eligible for relief. Then the person would have to show, in order to get the warrant, that the defendant poses a danger to another person. If they can do that, they can get the warrant. The person can get a warrant under this bill, and then the warrant gets forwarded, the whole thing gets forwarded to the state's attorney, who has to act within 72 hours. That's what I read the bill saying. Yes, I am.
I think you're reading an amendment that I put forward last week.
Yeah, you're looking at the wrong one.
I've got the over.
Just if I can get clarity again from council, how, in terms of the false statement versus perjury, how that goes down and how that's chosen? Because it's significant time. We're talking 10 years versus 1. How does that work?
Do you mean in terms of like a charging decision?
Are you subject to both?
Right. Yeah, I think as a practical matter, you'd be subject to both, even under current law, and or practice. So I had spoken with some representatives from the state judiciary, and my question to them was, under current practice, even though it's not in the statute, how is it handled when a citizen comes to the district court commissioner and files an application for a statement of charges? Is that done under oath? What would the potential range of options be if they lied under oath? And from talking with them, they advise that when anybody who's sworn law enforcement officers, they don't do this for apparently, but for anybody who's not a sworn law enforcement officer, they are required to actually, as you would in court, raise your right hand and, swear or affirm under oath that, you're telling the truth. And that they would be subject to penalties of perjury for making a false statement in an application for a statement of charges. And that's current practice, although it's not actually in statute.
Which is what I'm wondering, if that were to go to court and someone was to be charged with perjury.
Right.
And then they point this out, you have a conflict of law.
Well, no, not really. You have, so I think what we're talking about is that you have your perjury statute under 9101, but you've also got your false statement statute under 9503. You could be violating both and charged with both, at the same time. I think you might have a merger issue. I haven't really done the analysis on, whether that merges or not. But yeah, I think you could be charged and convicted on both. I don't know how the sentencing would play out. But I do have I have both statutes actually in your voting packet for you if you'd like to look at them.
Thank you, Mr. Chair. I've been reading through a lot of the things that we've been talking about and the ability of somebody to go to a court commissioner and get a temporary protective order, which is different. And there have been comments made about making sure that we're giving victims choices about the route that they want to pursue. And I think we are taking away by this bill a very important route for victims to pursue. And, somebody may need an arrest warrant, as we found earlier in the case that I mentioned to you. Somebody else may want just a temporary protective order. Somebody may not know about one or the other. And I think it's really important that for this specific set of victims that we preserve this ability for them to get an arrest warrant. And I think we can do it very narrowly. I think we can do it, just when the district court is closed. We can do it just for a specific set of victims. But I really would hate for us to close off that avenue for victims. I'm also wondering, Jamie, were there any concerns raised about summons being issued while a warrant is under review, thereby tipping off the defendant?
Thanks, Senator. Yeah, and talking with folks from the judiciary, they did have some concerns about that. When you have this staged process, my understanding from them is that there were some concerns about that. Not immediately being able to take a defendant into custody.
Mr. Chair, is there an ability to offer an amendment?
There's always an ability to offer an amendment. What I think we're going to do now, though, is obviously we go back to floor at what, 7 o'clock?
7:15.
7:15. There is a very important thing going on right now, so we need to just adjourn here, and we will come back to this bill. That's TBD, but we're gonna gavel out here right now, and then we will come back at some point during the session. Yes, Senator Fulton.
Thank you. Is there, I guess, Mr. Chair, we've consumed a lot of time on this, and we've had a very, lengthy discussion about it, and it's a House bill. So is there a reason we can't just go ahead and vote on it as it is with the amendment, and then the amendment can be added on the floor?
You can certainly do that if that's the pleasure.
I mean, I'd rather just move the bill and not have to come back and have more of a debate. We got a lot of other bills backed up behind this, waiting for a debate as well. So I'd like to make a motion to move the bill with the amendment. Yes.
Okay. So let's adopt the amendment first.
Okay.
Is there a motion?
Yeah, I take motion to adopt the amendment.
What do folks want to do? What's the pleasure? We adopt the amendment? Senator loves down the amendment. Say what? Down on the amendment.
Okay. And then now I'd like to move the bill with the amendment, as amended.
Down on the amendment. Are you down on the amendment, or are you up on the amendment?
Sarah, does that handle your issue for you? The amendment does it, right? Oh, it does not, okay.
Move the bill.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
No.
Senator West.
Yes.
Senator Muse.
No.
Senator Fulton.
Yes.
My chair meant to say yes.
Yes.
Got it.
I don't know if you want to put it verbally on the record.
Sounds like a seven.
Use mine. Yes.
Senator James.
Yes.
Senator Henson.
Yes.
Senator Love.
No, and I'd like to explain my vote. I really want to support this bill because I understand there are abuses to the commissioner system. And I think we really could have worked on this bill as we have in other ways in this committee, and we were about to do that. That just got cut short, and it's really disappointing that happened. I also want to address some really toxic things and ugly things that have been said about white feminists who oppose this bill and saying it's because they're racist. I'm a white feminist, and I'm proud of it. And I'm opposing this bill because we are taking away a very important tool for victims of stalking and victims of domestic violence. And who are those victims? Nearly 3 in 10 women and 1 in 10 men in the United States have experienced rape, physical violence, and/or stalking by a partner. So who are those victims? Well, 27.2% of Asian or Pacific Islander women, 41% of Hispanic women, 53% of Black women, 57% of American Indian or Alaskan Native women, 63% of multiracial women. Black women experience domestic violence at a rate 35% higher than white women. They're also more likely to be killed by their intimate partner. 40% of Black men have also experienced some form of intimate partner violence. All of these victims deserve protection. Women, men, Black, white, Hispanic, Native American, Asian and Pacific Islander. That is the reason I am voting against this bill.
Senator McKay,
Yes.
Senator Charles,
Yes.
Chairman Smith.
Yes. All right, so the vote, what is it? As amended, bill passes 10-1. This is a House bill subject to amendment even all the way up to third reader. The work will continue and the dialogue will continue, and we'll re-engage on this bill tonight and tomorrow. So thank you all very much. That'll conclude our voting session for the evening, or for now.